May it please the court. My name is James Lee, along with my co-counsel Bianca Flores, and we represent the petitioner Ashley Moody in today's case. The question presented before the court today is 1. Whether the law's content moderation restrictions comply with the First Amendment, and 2. Whether the law's individualized explanation requirements comply with the First Amendment. We argue that the law, SB 7072, is constitutional for the following reasons. First, social media platforms cannot have it both ways under the Communications Act of 1934. Second, when looking at the holding out test, social media companies are comment carriers. Third, social media companies are a means of hosting expressions. And lastly, the individualized explanation requirement does not violate the First Amendment.
Moving to our first point, social media platforms cannot 1. Receive the protection of Section 230, and 2. Also accept that protection while acting against the foundation of that statute. Specifically, Section 230 bases its shield on the basis that social media companies do not practice editorial discretion by dictating that no provider or user of an interactive computer service shall be treated as publisher or speaker of any information provided by another information content provider. Therefore, if social media companies don't receive publisher or speaking recognition and privileges under Section 230, then social media companies can't also practice editorial discretion, as it would contradict the explicit language found in the section. Essentially, social media companies cannot simply accept that protection outlined for them in Section 230 and then go on to claim to be editors or publishers through their content moderation practices. Moreover, while Section 230 also dictates that no provider or user of an interactive computer service shall be held liable on account of any action voluntarily taken in good faith to restrict access to or availability of material that the provider or user considers to be obscene, lewd, filthy, excessively violent, harassing, or otherwise objectionable, whether or not such material is constitutionally protected. This provision of the section and the protection it grants social media companies and the restriction of content only applies to obscene or undeniably provocative and indecent content. Moving on to our second point, Florida law has never established that communication services such as social media companies are not common carriers. The state of Florida has explicitly outlined that social media companies should be treated similarly to common carriers. Senate Bill 7072 in particular asserts that private social media platforms should be treated similarly to common carriers. And although it could and has been argued that social media companies are not common carriers when looking to federal preemption, this court should find that the FCC v. Midwest Video Corp. Definition does not directly conflict nor attempt to conflict with Florida law, and even if it did, federal preemption is not an issue that should persist in this case. Moreover, in common law, common carriers have been defined as entities that hold themselves out to provide services or good to the general public for a fee. Similarly, when looking to Supreme Court precedent, common carriers as applied to communication services have been defined by the court as entities that make public offering to provide communication facilities whereby all members of the public who choose to employ such facilities may communicate or transmit intelligence of their own design and choosing per Midwest Video Corp. Therefore, in keeping with Supreme Court precedent and state legislature, the court should find that federal preemption is not an issue that has been preserved upon appeal and has been previously denied certiorari in cases concerning preemption. 2, even if it had been preserved, the Florida law is not in conflict with it because of its specific language of how social media companies should be treated as common carriers. 3, there is no indication that the Midwest Video Corp definition was meant to occupy the field, or in other words, that the federal government intended to legislate in a field that had been traditionally been occupied by the states, per the court in Gay v. National Solid Waste Management. Moreover, common carriers must hold out a willingness to serve the entire public. In particular, when evaluating what constitutes common carriage, the court in National Association of Regulation, Utility Commerce versus FCC, found that common carriers that offer services made available to the public stands at the core of what defines a proper common carrier.
Why is social media so important today?
Social media is an essential tool in today's day and age. It serves as a modern-day public square as social media platforms hold out a willingness to directly serve the entire public through communications. Furthermore, social media use has boomed in the last 20 years. In fact, the percentage of US adults who use social media increased from 5% in 2005 to 79% in 2019. And in the United States, 240 million people out of 330 million people use social media.
How does the Florida law restrict social media platforms' ability to engage in content moderation by removing, editing, or arranging user-generated content?
Your Honor, this court should find that it doesn't. Florida only requires that when companies do engage in content moderation, they explain exactly why they are doing so through individualized explanations. Furthermore, Florida law operates more as a consumer protection law instead of as a limit on expression. It does not limit content moderation, but instead sets out requirements for social media companies to do so.
How does the Florida law require social media platforms to provide individualized explanations for certain forms of content moderation?
Your Honor, Florida law does require platforms to provide individualized explanations for certain forms of content moderation. However, it only sets out this requirement for certain specific instances.
Why did Florida enact its social media law?
Your Honor, Florida enacted its social media law to ensure that all political candidates can have a place to speak and to level the playing field.
What tier of scrutiny should the court review Florida's law with?
Your Honor, this court should find that rational basis scrutiny should be applied to our case, as Florida law doesn't violate the First Amendment. But even if this court were to apply intermediate scrutiny in our case, a higher level of scrutiny, Florida law would still survive, as FLFNB2 held that a content-neutral regulation of expressive conduct is subject to intermediate scrutiny, while a regulation based on the content of the expression must withstand the additional rigors of strict scrutiny.
Do social media platforms resemble newspapers which can control their own editorial content?
No, Your Honor. Although they are similar in that they both control their content, they differ significantly in that newspapers exercise editorial judgment protected by the First Amendment, as numerous precedents held, and that social media companies engage in content moderation that is not editorial judgment. Unlike newspaper editors who post extremely narrow choices of material that have been reviewed beforehand, social media companies use algorithms to filter out hate speech, spams, obscenity, etc., and then publish any other speech that did not get filtered out by the algorithm. It is for this reason that the control over editorial content for newspapers can constitute a speech, whereas that of social media cannot. Furthermore, while newspaper companies are liable for the messages on their platforms, social media companies are not, because the messages that are published on their platforms are not speech from the company itself. Therefore, because social media companies engage in content moderation that is outside of the scope of editorial judgment, which this court has found to be protected by the First Amendment, the company's control over editorial content does not resemble that of newspapers.
Does the compelled speech doctrine protect the rights of social media companies?
No, Your Honor. As the court found in Tornillo and Hurley, regulation over hosting can violate the First Amendment rights of the host only if the host has a desired message. However, as the social media companies have no desired speech, compelled speech doctrine is not applicable to social media companies. In addition, even if social media companies were to have a desired message through their action of censorship, the regulation on censorship do not interfere with their desired message, since the conduct of censorship itself cannot constitute speech. As demonstrated by FAIR, unless social media companies explain their reasoning behind deplatforming, shadow banning, or deprioritizing a candidate, a user will not know whether social media companies have a message or not.
Do social media platforms engage in commercial speech?
Yes, Your Honor. First, to determine if a speech is commercial, a speech must promote some type of commerce. To social media companies, messages, likes, and shares are the product. And as they're presenting this product to the public as free, open, and unbiased, the state of Florida has an interest in consumer protection to ensure that Floridians are explicitly made aware of how companies produce and alter their product. just as the government could lawfully mandate toothpaste companies to display ingredients for the product, or mandate that a drug company reveal any harmful side effects, it is completely lawful for the government to mandate social media companies to disclose the reasoning behind their censorship.
Will the Florida law increase or decrease free speech on social media?
Your Honor, Florida law will undoubtedly increase free speech on social media. First, it prohibits unreasonable silencing of messages on their platform. This ensures that both sides of the political spectrum have the chance to speak without the arbitrary limitations imposed by the social media companies. Second, it prevents social media companies from arbitrarily silencing speech by imposing harsh regulations at the failure to provide thorough explanation for their censorship. And lastly, the statute's intention, which is to ensure dissemination of information from multiplicity of sources, is, as the court held, central to the First Amendment. Therefore, the Florida law will definitely increase free speech on social media.
Does the Florida law create a slippery slope toward censorship?
Absolutely not, Your Honor. Although Senate Bill 7072 imposes regulations on social media companies' control over content moderations, it does not prohibit the social media companies from censoring out posts that are against the federal law. For instance, the 11th Circuit held that under the statute of Florida, journalistic enterprises will be able to post softcore pornography. However, under the federal law 47 U.S.C. section 230, such obscene and lewd materials can and will be filtered out by social media companies. Rather than completely disabling social media companies to have control over their content, SB 7072 prohibits social media companies from exploiting their power to prevent the public from having access to a multiplicity of information, which is extremely central to the First Amendment, as the court in turn held. Thus, Florida leaves no room for a slippery slope towards censorship. Moving on to our last argument. Although the 11th Circuit correctly recognized that Senate Bill 7072's disclosure provisions should be tested under Zarder, it erred in concluding that notifying users when they are censored is too burdensome. The platforms themselves, after all, have called for notice to each user whose content is removed or whose account is suspended, about the reason for the removal or suspension, and to offer detailed guidance and examples of permissible and impermissible content. Furthermore, the 11th Circuit also held that this provision chills protected speech, which is editorial judgment of social media companies. However, as described previously, the editorial judgment of newspaper editors and the content moderation of social media companies differ significantly. Unlike the newspaper editors, social media companies simply use algorithms to filter out any content that is prohibited by the federal law or is against their community guidelines, and virtually host any other speech. If this individualized editing by algorithm is enough to be considered as an editorial judgment, then an individualized explanation using an algorithm developed by social media companies must be enough to meet the requirement of Senate Bill 7072, which is extremely likely to be not burdensome for social media companies.
In conclusion, Senate Bill 7072 does not violate the First Amendment. Firstly, social media companies can't have it both ways under Section 230. They can't get the protection listed under Section 230 and then go and practice content moderation through editorial discretion, which is against the foundation and basis of Section 230 itself. Secondly, social media companies are common carriers, as the status of social media platforms as common carriers does not conflict with state law. Additionally, social media platforms hold themselves out directly to the public, which aligns with perhaps the most common definition of common carriage. Therefore, these platforms receive a lower standard of First Amendment protection than other forms of communication.
Third, even if social media companies were not common carriers, social media companies are means of hosting expression. As shown by the content moderations of social media companies, they do not exercise editorial judgment, nor do they produce speech themselves. Rather, they act similarly to the shopping centers in Pruneyard by hosting speech, and thus the regulations on content moderation is constitutional, as the court has previously found. And lastly, disclosure requirement is not burdensome for the social media companies. If algorithms are enough to create editorial judgment, then algorithms must be enough to constitute an individualized explanation. It is for these reasons that we pray that this court reverses the decision of the 11th Circuit. Thank you.